Pleasant day to you, ma'am. I'm Ramel Cañete, and for today, I'm going to discuss the Chapter 3 in Legal Aspects in Tourism and Hospitality, the laws and obligations. So, but before I start, I'll quote this saying, the ethical basis of business is integrity, an ethical aspect that unites both private morality and public professional ethics. And this is by Don Skelly, Colorado Technical University. So the objectives for this topic is first is to identify the different kinds of obligations and contracts. Second is to enumerate the ways of extinguishing an obligation. And lastly, to enumerate possible application of contracts in the tourism, travel, and hospitality industry. So a person desiring to engage in a business in the tourism, travel, and hospitality industry will meet certain obligations. Agreements will be encountered and potential breach from these agreements will be encountered also. So obligations. So what is obligation? Obligation is a legal duty, however created, the violation of which may become the basis of an action law. In the Article 11156, an obligation is a juridical necessity to give, to do, or not to do. There are four elements of obligations. The first element is an active subject. An active subject, also known as the obliged or the creditor, who has the power to demand the prestation. The second element is a passive subject, known as the debtor, who is bound to perform the prestation. The third element is an object or the prestation, which is an object or undertaking to give, to do, or not to do. 4. The juridical or legal tie, the vinculum which binds the contracting parties. The juridical tie or vinculum is based on the sources of obligation arising from either the law or contract. In Article 1156, obligations arise from first law, second is contracts. So in contracts, contracts is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some services. Next is quasi-contracts. Quasi-contracts refers to a lawful, voluntary, and unilateral act based on the maxim that no one shall unjustly enrich himself at the expense of another. Next is the acts or omissions punishable by law. And lastly, quasi-delicts. Quasi-delicts. Quasi-delicts, also called culpa aquiliana, is any act or omissions which causes damage to another, there being fault or negligence, and there being no pre-existing contractual relation between the parties. There are also classifications of obligations. First is primary classifications of obligations under the Civil Code. So under this, there is pure and conditional obligations. This can be seen under the Article 1179 and 1192. Pure obligation is one which is not subject to any condition and no specific date is mentioned for its fulfillment, and there is therefore immediately demandable. A conditional obligation is one whose consequences are subject in one way or another to the fulfillment of obligations. Next is the obligations with a period. This can be read in the Articles 1193 to 1198. An obligation with a period is one whose consequences are subject in one way or another to the fulfillment of conditions. Next is the alternative and facultative obligations. This can be read in Article 1195 to 1205 and Article 1206. Next, the joint and solidarity obligations. This can be be read under the Article 1123 to 1225. Joint obligations with a period is one whose consequences are subject in one way or another to the expiration of the said period of time. Solidarity obligations are those demand and each debtor is bound to perform. And lastly, divisible and indivisible obligations and obligations with penal clause. Second, classifications of obligations under the Civil Code. Secondary classifications of obligations under the Civil Code is unilateral and bilateral obligations, real per- real personal obligations, civil and natural obligations, legal and conventional and penal obligations. So there are modes of extinguishing obligations. Under the law, in Article 1231, obligations can be extinguished. First, by payment or performance. Second, by the loss of the thing due. Third, by the condonation or remissions of the debt. Fourth, by the confusion or merger of the rights of the debtor. Five, by compensation and by novations. Contracts in Article 1305. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So there are essential elements of contracts. First is consent. Consent, consent which is manifested by the meeting of the mind of the offer and the acceptance upon the thing and the cause which are to constitute the contract. Second is the object certain, which which is the subject matter of the contract and the cause of obligations. And last, cause of obligations which is established. So there are classifications of contracts. First is according to the relation to the other contracts. There is preparatory, or those which have for their object establishment of a condition in law which is necessary as a preliminary step towards the celebration of another subsequent contract. Principal, or those which can subsist independently from other contracts and whose purpose can be fulfilled by themselves. Next is the accessory, or those which can exist only as a consequence of or in relation with another contract. Second is according to their perfection. Under this, there is consensual. Consensual are those which are perfected by the mere agreement of the parties. Second is real, those which require only the consent of the parties for their perfection, but also the delivery of the object by one party to the other. Third, according to their form. Common or informal, which require no particular form. B. Special format, those which require some particular form. Next is according to their purpose. This is a transfer of ownership, conveyance of use, rendition of service. Next is according to their subject matter, things and services. Sixth is according to the nature of vinculum. Under this, there is unilateral, those which type gives rise to an obligation for one and only parties. Second is the bilateral, those which gives rise to the reciprocal obligation for both parties. 7. According to their cause, there is onerous, Onerous those which each of the parties aspires to procure for himself a benefit through the giving of an equivalent or compensation. Letter B. The gratuitous, those in which one of the parties proposes to give to the other a benefit without any equivalent or compensation. And 8. According to the risks involved. First is the cumulative, those which where each of the parties acquires equivalent of his prestation moment of the celebration of the contract. B. Aleatory, those which each of the parties has to its account to the acquisition of an equivalent of his prestation. Lastly, according to their names or norms. First is the nominate, those which have their own individuality and are regulated by special provisions of law. Second is innominate, those which lack of individuality and are not regulated by special provisions of law. So that would be all for the chapter 3. Thank you and have a great day ahead.